Labor Law of Cambodia, 1997, Provisions on Labor Contract. Chapter 4. The Labor Contract. Section I. Signing and execution of a labor contract. Article 65. A labor contract establishes working relations between the worker and the employer. It is subject to common law and can be made in a form that is agreed upon by the contracting parties. It can be written or verbal. It can be drawn up and signed according to local custom. If it needs registering, this shall be done at no cost. The verbal contract is considered to be a tacit agreement between the employer and the worker under the conditions laid down, stated, by the labor regulations, even if it is not expressly defined. Article 66. Everyone can be hired for specific work on the basis of time, either for a fixed duration or for an undetermined duration. Article 67. 1. A labor contract signed with consent for a specific duration must contain a precise finishing date. 2. The labor contract signed with consent for a specific duration cannot be for a period longer than 2 years. It can be renewed one or more times, as long as the renewal does not surpass the maximum duration of 2 years. Any violation of this rule leads the contract to become a labor contract of undetermined duration. (3) Sometimes, this contract may have an unspecified date when it is drawn up for replacing a worker who is temporarily absent, work carried out during a season, occasional periods of extra work or a non-customary activity of the enterprise. This duration is then finished by the return to work of the worker who was temporarily absent or the termination of his labor contract. The end of the season. The end of the occasional period of extra work or of the non-customary activity to the enterprise. 4. At the signing of the contract, the employer must inform the worker of the eventually sensitive issues and the approximate duration of the contract. 5. Contracts without a precise date can be renewed at will as many times as possible without losing their validity. 6. Contracts of daily or hourly workers who are hired for a short-term job and who are paid at the end of the day, the week or fortnight period, are considered to be contracts of fixed duration with an unspecified date. 7. A contract of fixed duration must be in writing. If not, it becomes a labor contract of undetermined duration. 8. When a contract is signed for a fixed period of or less than 2 years, but the work tacitly and quietly continues after the end of the fixed period, the contract becomes a labor contract of undetermined duration. Article 68. A contract for a probationary period cannot be for longer than the amount of time needed for the employer to judge the professional worth of the worker and for the worker to know concretely the working conditions provided. However, the probationary period cannot last longer than 3 months for regular employees, 2 months for specialized workers and 1 month for non-specialized workers. The round travel costs incurred by a worker during the probationary period when working far from his habitual residence are to be covered by the employer. Article 69. Within the framework of his contract, the worker shall perform all of his professional activities for the enterprise. Primarily, he must do the work for which he is hired, and perform it by himself with due care and attention. However, outside working hours, the worker can engage in any professional activities that are not in competition with the enterprise for which he works or that are not harmful to the agreed process of performance, unless there is an agreement to the contrary. Article 70. Any clause of a contract that prohibits the worker from engaging in any activity after the expiration of the contract is null and void.